Welcome to the program Law and Order. Not knowing the law is not an excuse. You must know the law and you must not let yourself in trouble. If you don't know the law, that is not a reasonable excuse. So, in our series of programs, Law and Order, we discuss numerous disciplines, numerous topics and educate you about the legal environment. So, today also we are going to sort out an important topic with regard to the property law related to the condominium property, as we discussed in our previous episode. It is parate law. We'll be discussing about parate law and what parate law is, how does it apply. So simply, when it comes to that parate term, you might not be much familiar with because it's a legal term, but behind the legal term, there are certain things we have to discuss. So, to do the honors, we invited Mr. Senaka Diseram, attorney at law. So, thank you very much, sir, for accepting our invitation and being here with our studios for this discussion. And so, as an exposure, what parate law is?
Thank you for the invitation. Yes, so parate law is basically where if you have mortgaged your property to a bank, the legal statutes, the parate law, the Bank of Ceylon Act, the People's Bank Act, they give the banks the power, if you are in default of that facility, to execute an auction on your property without going to court. As you know, if you are to execute a mortgage right, you have to go to court and you have a right of being heard. There is a long procedure of a trial. But here nothing of that sort happens. They will simply start by informing you that you are in default. Next, they will send you a notice saying that they have passed a board resolution now. Then they will send you another notice with a gazette and paper notices saying, look here, we have published this board resolution in the newspapers and the gazette. Then they will set a date for auction, and thereafter they will set another newspaper and a gazette notification saying, okay, this is going to be auctioned off on this day. So you can see this whole process takes place one-sided from the bank's point of view, but it's not illegal. The law provides for that. That is the whole process of parate, and that is why you need to be careful of it.
Right. So that means, sir, we are obtaining a loan. If we are default of that facility, the bank will exercise their powers with a board resolution, and without a court intervention, they set out the formal procedures in auctioning that. It's like a nuclear option.
Yes.
Isn't it like injustice? Although the law provides, isn't it an injustice for the buyer or the purchaser or the owner?
Yeah, there are two sides to this. The bank will not execute parate unless you are in default. So basically, you have been in default, they have informed you, then they have sent the file to the legal department, they have sent you a letter of demand, notice of auction. So all this is about 6-7 months. So if you, from the bank's point of view, they don't collect the money they have lent, they will fall into trouble with their depositors and things like that. As you know, Sri Lanka is very vulnerable now. If our banks fail today, we are in a soup. So that is that angle. The other angle is absolutely correct what you said. It is a nuclear-like option. They have absolute power in going ahead with this process, and they can do it very quickly. So what people don't understand is all banks have very good legal departments, so they don't need legal advice either. They have done this over and over again. Though it's new to you, it is a thing that they do it all the time. So they know what to do, when to do, and don't think you can outsmart them on that, because they are experts in that. They have been doing it. They have a legal team who have been doing it. So when you are in default, don't wait till that last minute, because it's like a freight train coming at you. You can't stop it. So only way to do it is get proper legal advice as you are in default. Don't wait till that last minute.
Right. That means, sir, if the loan is not performing, it's like non-performing loans. The bank need to exercise a certain strategy. As you all know, they have legal departments, and even the recovery of the loans, if that is not performing, they will fall in trouble with their lenders and paying interest and so on and so forth. There are many things to consider. But when it comes to this parate execution from the side of the purchaser or the customer, it seems, I might feel, if I'm the customer, I have a reasonable excuse for this. For example, I have a grave illness or a certain other things, irreparable damage. In that case, can we have legal advice and consult a bank to not to execute parate?
Yes. Now, there is two sides to that. if you take the central bank issued certain moratoriums. So they gave certain industries a break. So you can't execute parate on those facilities, tourism, certain arts. So from time to time, the central bank is observing the country's situation, and they have made sure that not all industries are affected by the parate law. The other one is what happens if a situation is not covered under those circulars. So you can definitely go to the bank and have a chat with them and say, look here, this is my situation. So if you have been good previously, they may consider stopping the process on allowing you to pay a reduced amount, but that is all their negotiation with you. And they will look at you and see what is your problem and things like that. For example, when the tsunami hit, there were issues where the entire industry got so they didn't go. You must also consider that banks are not interested in your property, because at the end of the day they have to sell it to somebody else to recover. That is also a burden to them. It's better if they can get hold of you and get you to pay the loan rather than go through, because it also involves expense. So that the two options are there.
Then at the last minute, nothing can be done. So if you want to negotiate the bank, your negotiating power matters. If your history is good, if you have a good reputation with the bank, if your transactions are probably fine, they will grant you some relief, but not at the last minute. There is a procedure that, as our guest said, a formal procedure that they will adopt, publishing notices and certain proceedings that they will do, and once after a lapse of 6-7 months only, they will initiate the auction. Am I correct, sir?
Yeah, it will take about that time for the whole thing, from the day they notified you that you are in default to the auction date. It will take a good 5-6 months.
Right. And just a small question that I have arisen, like from the general public's point of view, I think they might consider, can banks execute parate on any property?
No, they can't execute on any property. Now, if you take, there was an amendment to the law, as you know. So below 5 million, if your capital is below 5 million, they can't. Then if it's a third party loan, for example, I have taken a loan for myself, mortgaging your property, then the banks can't execute parate on yours. They'll have to file a normal mortgage bond action. Then also there are situations where they have made a mistake. Though I said the experts are there, sometimes you see there is the offhand where they have made mistakes on your account statement, on the publication where your property is not properly disclosed, the figures are different. So in those situations, they will not go ahead, and if there is a situation like that, you can go to a court and stop the auction. We have done that. Like if any of those factors are there, then you go to court and get a stay order on the auction. And most probably if there is a mistake like that, they come and rectify it and say we will not go ahead with the auction, and the case ends there.
Right. So then when having a stay order from the court itself, that means there is a particular court intervention from the side of the customer against the bank when they are to execute parate. So how can that probably take place, sir?
Yes. So as I told you earlier, and as you also said, don't wait till the last minute, because some people come to us saying the auction is next week. There is nothing we can do. We are not magicians. Right. So you have to make sure you build up your case. So that is from the day you know you're getting into difficulty, go and meet somebody who knows this subject and discuss with him how we are going to strategize, so that while negotiating with the bank, we build up a case also in case our negotiations fail, we can go to a court of law and stop this. Right. So you can't do that overnight, because some of these people, they are good businessmen, but they are very bad people at collecting documents and keeping documents. So they come to us with only that notice or the paper notice. That's all they have. So when you're dealing with a bank, don't take them for granted. Collect every scrap of paper they send to you. Any registered post letter, any letter, have a file and just put it in. Don't be bothered. If you can't understand it, that's okay. When you take this file to somebody, that person will understand. It. But don't put it into the bin.
Right.
Like what most people do.
Yes.
So if you go to a bank and have a loan, from that day, ask them, where are the documents I signed? Give me copies. Give me the copy of the mortgage bond. Don't just wait silent. If they don't give it, keep writing. I have taken this loan. Please give me these documents. Moment you get it, file it. Moment they send you letters, read it. If you can't understand it, go to somebody who can understand it. And if they are telling some falsehood, don't wait without replying. Reply those letters.
Right.
Have all this correspondence, so that if you do fall into trouble, then you have a very good set of documentation to defend your situation. Otherwise, sometimes it is very sad to say they have a very good case, but nothing is documented.
Right.
So if nothing is documented, what are you going to tell the judge? A judge is not going to give you an order merely on what you are going to say in court. You can't talk in court also, because the lawyer will talk on your behalf. And if you don't have anything to say to the lawyer, what can the lawyer say to the judge?
The documentation thing, you have to maintain it properly. Otherwise, if you might have a good case, as you said, sir, but they don't have any formal proof, evidence to prove that we have evidence. We must have evidence to prove a certain thing, because like from your side, you need to produce those documents and evidence. Then only the person who is speaking on your behalf, might be an attorney at law, he can do the needful to your favor. And so like when it comes to those parate executions, for example, that we discuss about the stay order applying thing, and for the other side of that, the cases are being proceeding and they have set the date for the auction. Can we stop? Suppose one thing, I'm just willing to pay that the entire sum of money. Can we stop that auction?
Yes. Now the Act has two provisions. If you pay 10%, they can consider stopping. But if you deposit the entire money on the resolution, then there is no case for them.
Right.
They can. But 99% of the time, you can't do that.
Yes.
You are in a total mess when this is happening. That is why you have defaulted. I don't think anybody willfully defaults.
Yes.
And you willfully defaults. So it's a situation where you don't have money. So the way where the situation may arise, what you are talking is where you may have an investor.
Yes.
You may have a buyer. Then the buyer will come and settle the bank and stop the whole process. But it's available. You can do it.
Right.
You can do it. But sometimes these banks, when they know you are in trouble, they also keep to those exorbitant interest rates, penalties, everything is, even the auction fee is added.
Right.
So you may feel it's unfair. You may feel it's unfair, but that is the unfortunate situation.
That means if the defaulted amount is somewhere around 10 million, once at the end of the day, once all those things are settled, the auction fees, legal fees, it might increase to a massive number.
It increases, and they add on, and they say, no, now we have incurred the auctioneer's fees, about 200,000, that also you need to pay.
Right.
So that is why I say don't wait till the last minute. So if you can take the issue at the beginning stage, then there is no auctioneer's fee and all, because the auctioneer is not in play.
Right.
Then it's only to negotiate with the interest and the penal interest, which they accommodate sometimes.
Right. Okay. So a question that I just got to answer and ask from you, in that from the general point of view, once again, sir, if I'm going to buy a property which is being about to be executed, this parate law, what things do I consider? For an example, if I am the person who is going to buy that property. So a person named A, he has been defaulted with the bank B. So I'm going to purchase it from A, not B, or what is the relationship there?
There are two ways you can do it. You can wait for the auction and purchase the property at the auction.
Right.
You can purchase it at the auction. That is the safest bet, because then you get very good title. The other bet is to negotiate with this the person A you are talking of.
Right.
So the difference is when you negotiate with person A and do it, you can get it at a lesser price.
Right.
So that is the benefit. So then it is advisable that you negotiate with him, talk to the bank, get a letter from the bank saying this is the outstanding amount. This is the outstanding amount. Once that outstanding is settled, you will release the mortgage on it. So you need the confirmation from the bank, not what Mr. A is going to tell you, because he will not tell you the proper.
Right. So we need to consult the bank. If we are purchasing from that particular person who is defaulted with the loan, we can just go into a lesser negotiation. But from the bank side, they will just demand a certain higher price. Other than that, sir, if we have somehow bought a certain agreement, properly manipulated, properly formed, with proper legal consultations, will we fall in trouble purchasing that?
There is an issue, because sometimes though the property is transferred, that particular person is still in occupation. So if he doesn't leave, then you have to go to court and get him out. Of course, it's not a lengthy process. It's a summary procedure case that you file in the district court to get him out. So if you are buying a property like that, it's always advisable to see whether he is in possession. If he is in possession, it will be problematic, so you will have to talk to him and see what's happening. If he is not in possession, then you have no issue with the auction. You can go into possession and occupy. As you know, in property law, possession is the most important.
And like in certain cases that we file, only the possession for last 2 months or couple of months is been considered.
They will come and put a container there, and that's it.
That's it.
That's what's happening now in Colombo.
Yes. And so like apart from that, if we are checking the possession, if that for example we have bought the property but we can't still move that particular person in possession to move out from the property, so we have to file court case. So in that case, can they take that defense that we have been occupying this property?
No, because once the auction goes ahead, then the title of the property rests with the bank or with you if you have bought it.
Right.
So then it's a matter of just going ahead with the possessory action.
Right. And what we discussed about in our previous episode with condominium law, and there will be certain developers who will mortgage that entire unit to the bank and resell each and every single small apartment pieces to the other buyers. So in that parate execution, if that developer obtains a loan from the bank, so they can execute parate. So as we were discussing about the condominium law, we said that so we need to have a notice of release or something like that, a proper documentation that this thing will not affect our property. So if it has been affected, what can we do?
Yes, now that's a very good question when it comes to buildings, condominium buildings, is until a condominium plan is registered, that building is not owned by the persons who have bought those condominium. It is still owned by the guy who is the developer or the person putting up, the guy who owns the land at the bottom of the building, to put it very simply. So he has mortgaged it, as you said, he has mortgaged it to a bank. But then what happens to those unit holders? So once the condominium plan is registered, then when you are getting the transfer from the developer, you have to ask the developer what's going to happen to that mortgage that you have taken. So what you do is then the developer gets involved and he speaks to the bank and gets a deed of release on your particular unit. So that has to be registered together with your deed. Then when you are going to sell next time, people can see there has been a mortgage, but the bank has said there is that. So the banks generally do that. They look at their exposure, they look at how many units are there, and when you pay the money, sometimes you might be, if the facility is in default, you pay the money directly to the bank, though it's the loan of the developer, and then they will release it for you. So you have to watch that. It's a very good question that you asked with regard to
Okay, so when it comes to that particular sequence, when that parate execution, this question I asked in our previous episode as well for condominium property. We have that property only, but it's not related to parate as we were discussing in our previous thing. But here, when the parate law is being executed, if that is our only property, can that be a defense?
No, it can't be, because you basically, the developer has mortgage the property and you have no right to that property. You have only a sales agreement until you get a deed. So then when you go to register the deed also, you are aware there is a mortgage. So your defenses with regard to the fact that this is your only property, as you know, I think you are referring to the problem where when you are living in a house, you can't execute a normal civil decree on that. But it does not apply to parate and mortgage bond actions. So if it's a mortgage, if it's parate, if it's your living house, you are not having any safeguard, so you have to be watchful of these things.
So we discussed about parate law and certain consequences, and so apart from this parate law with regard to condominium property, I would like to enlighten a small thing which is controversial as in, like, it's been discussed majority, like people tend to discuss that topic, the port city thing with this condominium law. And what is the relationship, sir?
Port city has its own regime to run the port city, but there is an interesting point where it says that the condominium law which is existing at the moment will be applicable to the port city as well. So what people said that it has a different regime, laws and all will not apply. But the UDA law does not apply. So they will have their own rules for UDA provisions, but until they make regulations, the present law for condominiums will apply there as well. So parate, all that will be applicable in the same way.
In the same way, no change. So if you are going to purchase a property there, the same law, same legislation will apply. And so like some people tend to say that the Sri Lankan law will not apply. For example, for these loans and the recovery of loans and the Banking Act will relate with this. So is there any particular difference from that property?
No, I don't think so, because it's still the property of Sri Lanka. It's not an alien property. So the same rules and laws will apply. So it's yet to be seen what the Commission will do with regard to regulations, because there is a section there which says if the Commission puts out regulations, then those regulations supersedes other regulations, but it doesn't supersede an act of Parliament.
Yes.
So I think the parate laws, those laws will be still applicable there.
So it's a if you seems to be a good investment, you can invest in that area as well. So I enlightened this port city concept because currently it's being discussed widely, and you might be having certain ideas. And so in a program that we discuss condominium property law and parate law, and in a series of programs where we enlighten you about legal environment, so we need to enlighten in that matter as well. So no issue with regard to that, so you can proceed. But what we discuss about the parate law and the all other things, they will affect usual when it comes to that thing as well. So as we're running out of time, sir, we'll just wind up today's program, and we'll be discussing some interesting topics in the future as well with regard to the program Law and Order. So thank you very much, sir, Mr. Seneka Diseram, attorney at law, for joining with us to discuss about parate law today as well. Thank you, sir.
Thank you for that.
Right, so stay tuned with Law and Order. In our future episodes, we'll be discussing more interesting topics as well. Thank you very much for watching. Have a pleasant day.